Hi, I'm Denise and you're watching Law with Denise. This is a case summary of White and Chief Constable of South Yorkshire, 1999. In this video, I will outline the facts of the case, I will explain the decision reached at first instance, in the Court of Appeal, and finally in the House of Lords. So what are the facts of this case? This case arose out of the Hillsborough disaster which occurred on April 15, 1989 at the Hillsborough Football Stadium in Sheffield, England. The case was started by police officers who were psychiatrically injured as a result of their involvement in the disaster. Now, initially there were 52 police officers, serving police officers who commenced cases. It seems 15 abandoned their cases, and 14 judgments were reached. Of the remaining proceedings, 6 were chosen in order for the courts to look at the issue of liability. It's these 6 claims which make up White and Chief Constable of South Yorkshire at first instance. So at first instance, these 6 claims unfortunately failed. So the police officers failed. In fact, 5 of them appealed, and this appeal went to the Court of Appeal. Of the 5 who appealed, 4 were successful. But the defendants then appealed, and this appeal went to the House of Lords. So let's look firstly at who the defendants were. So there are 3 defendants in total, but the issue of liability was tried against the Chief Constable of South Yorkshire, hence our case being called White and Chief Constable of South Yorkshire. And one of the police officers was White. So it's really White and others and Chief Constable of South Yorkshire. What did the claimants argue? What did the police officers argue? They argued that the incident was caused by the negligence of the officer who was at work at the time, and that he was given instructions by the Chief Constable of South Yorkshire. So as a result, the Chief Constable of South Yorkshire was vicariously liable, and as a result of their position as employees, they should be given damages. Secondly, they said that they could be seen as rescuers, but that they should be put in a special category of rescuers. Now, the defendants admitted negligence, but there was an issue of liability. And at first instance, the judge said they were not liable. And the judge was not convinced by the arguments put forward by the police officers. So one, they could not recover damages as employees. The judge at first instance was concerned with the fact that their employer and employee relationship was different to other employer and employee relationships. He pointed out that as police officers, it is quite normal for police officers to be exposed to situations which would lead to them experiencing nervous shock. And therefore, just because they were exposed to that doesn't mean that they were automatically entitled to damages. He said that they would have to convince the court that there was some reason which made it fair and reasonable for them as police officers to recover damages, but not the ordinary person. So on that ground, they failed, and the judge was also not convinced that they were to be classed in a special category of rescuers. Then 4 of them did appeal to the Court of Appeal, and the Court of Appeal said that 2 of their cases could succeed, or rather did succeed, on the first ground, being that they were employees, and 2 of them did succeed on the second ground, being that they were in a special category of rescuers. And then the defendants appealed to the House of Lords. Now, what did the House of Lords say? In response to the first argument based on the employer and employee relationship, the Lords said the following. They said, yes, the employer did have a duty to take reasonable steps to protect employees from physical harm, but because no physical harm was suffered, there could be no claim for psychiatric harm. So the first ground of argument was dismissed. In response to the second argument, being that they should be put in a special category of rescuers, this is what the Lord said. The Lord said that no physical injury was reasonably foreseeable to them. Therefore, they could not recover damages merely for their witnessing of the incident or the aftermath of it. There was no special category for this. They simply would fit into the category of secondary victim, which was outlined and confirmed in Alcock and Chief Constable of South Yorkshire 1992. And in Alcock and Chief Constable of South Yorkshire 1992, the Lords pointed out, if one fits into the category of secondary victim, they need to pass the control mechanisms outlined in that case. And unfortunately, none of the police officers could pass the control mechanisms outlined in that case. So therefore, their claim failed on this ground as well. Thank you.